Good day. My name is Louwrens Bakker. I'm a legal advisor with SEESA's Consumer Protection and POPI Department.
Good day. My name is Damian Bothma. I'm also a legal advisor of SEESA at the Consumer and POPI Department. Today we're giving a brief overview of the POPI Act. Louwrens, could you tell us what the POPI Act is?
Certainly. The POPI Act is the Protection of Personal Information Act, and its general purpose is to set out the guidelines and the requirements that businesses have to follow when it comes to using and processing personal information.
Okay, and what does personal information entail?
Personal information is defined by the Act as any information relating to an identifiable living natural person, or, where applicable, an identifiable existing juristic person. The Act then goes further to give examples of what kind of information will be regarded as being personal information. It gives examples like name, ID number, telephone number. A company's registration number can also be regarded as personal information, as well as biometric information.
Okay, and can you tell us more about the application of this Act?
The Act will apply to the processing of personal information by or on behalf of a responsible party domiciled within South Africa. What that basically means is that where any business situated within South Africa uses personal information on a daily basis for whatever reason, the Act will apply to the processing of that information. It's also important to note that the POPI Act is the highest authority when it comes to dealing with requirements of processing of personal information.
And how does this Act protect information?
The Act sets out the 8 conditions for the processing of personal information. These conditions are accountability, processing limitation, the purpose specification, further processing limitation, information quality, openness, security safeguards, and data subject participation. We'll discuss these conditions in a lot more detail during one of our next discussions.
Great. And will this Act finally stop this frustrating direct marketing?
We really hope so. The Act sets out the rules that companies have to follow when it comes to direct marketing. And it says that a company may only do direct marketing towards a data subject if that company has the consent of that data subject, or if that data subject is already a client of that company.
And what happens to a company in terms of non-compliance?
Where a company is not complying with the POPI Act, the information regulator is empowered to lodge an investigation into that company and into their compliance with the Act. Based on that investigation, the information regulator will find whether or not there is compliance. And if they find that there is non-compliance, the company may be fined or issued with other penalties. The fines that the information regulator can issue can be up to 10 million rand.
Sure. Thanks, Louwrens.
Yeah, big pleasure.
As this is a fairly new legislation, we as legal advisors at SEESA would like to assist our clients in terms of implementing the complexities of the POPI Act. If you guys want any further information, you are more than welcome to visit our website to get our contact details. Thank you.
Thank you, Damian.